Welcome to StudyAssistant.org video tutorial. Each tutorial is voice activated. This video presentation is on the topic of the concept and characteristics of contract law. At the end of this tutorial you should be able to explain the concept of contract and describe the characteristics of a simple contract. The concept and characteristics of a simple contract. Contracts are common in the business environment. A contract is an agreement, which usually contains specific terms, between two or more persons, business entities, or businesses and individuals. Parties to a contract make a promise to do something in return for a valuable benefit known as consideration. Contracts made could be oral or formally written. However, it is the written contracts that are easier enforced in a court of law. Most times, oral contracts are difficult to prove. Then there are unilateral contracts and bilateral contracts. A unilateral contract is one in which a party promises to pay or give something for some performance without the expressed promise of performance from the other party who acts on the promise. For example, a unilateral contract exists if I promise to pay Val $40 to wash my vehicle today and he acts on my promise. Val does not promise to wash my vehicle today, but I expect him to do that. Once Val washes the car today, a unilateral contract exists. The obligation to pay is on my part. Val is not obligated to wash the vehicle, but if he does, the contract exists and I must pay Val the $40 I promised. A popular example of a unilateral contract is a reward notice. These types of notices are posted in newspapers, shop windows, walls, etc. They offer a reward to anyone who can perform some act, such as returning a lost dog, finding a loved one, etc. No one is under any obligation to look for the lost dog, or find the loved one. However, if one person acts on it and returns the lost dog, or find the loved one, the one who makes the promise is obligated to honor his or her promise. On the other hand, if both parties make a promise to pay or give something for some performance and acts on their promise, this agreement will give rise to a bilateral contract. This is the most common type of contract. A good example of a bilateral contract is the agreement for the sale of a home. A bilateral contract exists if I promise to pay $100,000 to Jake, a seller of a house, who promises in exchange to deliver the title of the deed for the property to me. As you have observed, businesses find contracts helpful because they protect them and their resources. Now, a contract only exists when the following factual elements are present: an offer, an acceptance of that offer, a promise to perform, a valuable consideration, which can be a promise or payment in some form, a time or event when performance must be made, to meet commitments, terms and conditions for performance, including fulfilling promises and performance. Characteristics of a simple contract. A binding and enforceable contract by law has the following four essential elements. They are mutual assent, competence of parties, intention to create legal relations, and consideration. Let's have a look at these elements for an enforceable contract. Mutual assent. A valid contract starts with the existence of mutual parties who come together to form an agreement. The agreement is set forth by an offer and acceptance of the terms of the agreement, which must be in writing to be enforceable. The consent to enter into a contract by both parties must be mutual, not obtained by fraud, misrepresentation, duress, undue influence, or mistake. If a contract is entered in such a way, the contract is not real and therefore it becomes invalid. Let's have a look at the case to understand what mutual assent is about. Jane has a small cake store. Janice pays Jane $175 for a birthday cake which should be delivered to Janice on a particular day. Jane gives Janice a quotation for $175. Janice makes the offer to Jane, who in turn accepts the offer when she gives a quotation to Janice. The quotation shows Jane's willingness to be bound to the terms of the contract. These two elements contribute to a valid contract. The offer and acceptance is clearly stated. Both parties enter the contract knowing what is expected of both parties. Both voluntarily consent to the terms of the agreement without any undue influence, misrepresentation, fraud, duress or mistake. Consideration. Another element that makes an enforceable contract is consideration. Consideration supports an agreement, and it is not always in the form of money. Consideration can be a promise. Therefore, most law books define consideration as a promise or an act of legal value bargained for and received in return for a promise. This legal value is a benefit or a detriment. In a contract, both parties must receive consideration. According to the case earlier, Jane's promise to bake a cake and deliver it to Janice on a particular day, and Janice's promise to pay the $175 is sufficient consideration for both parties. Both parties now receive some benefit and suffer some detriment or loss. This case shows that both parties were not previously obligated to do something for each other and thus not entitled to receive something they are not entitled to receive. Now, if someone offers to pay a police officer $2,000 as a reward for recovering stolen items, the police officer is doing no more than what he is obligated to do. Therefore, the police officer is not suffering any detriment in performing the act, and the citizen is receiving a service that he or she is entitled to. Consideration in this instance makes the contract invalid. Consideration can also be done to show good faith. When someone makes partial payment on the purchase price of a piece of land, the partial payment or good faith money indicates that the buyer will pay the rest of the money. Competence of parties. Another element that determines if a contract is enforceable is the legal capacity of all parties to the contract. Certain persons have no full contractual capacity according to public policy or some disability. They are minors, mental defectives, and intoxicated persons. Now Janine, a minor of 15 years old, pays $110 for a bathing suit. Janine takes the bathing suit home, tries it on, and finds it does not fit properly. She carries it back to the store that sold her the suit and demanded a refund. The store owner claims their policy will only allow Janine to get a refund of $90. Now, a minor in the Trinidad and Tobago is under 18 years of age, and such minors have the right to cancel or disaffirm their contracts with no liability other than the return of any proceeds they received under such contract. Minors, like Janine, are protected under the law due to their lack of experience, judgment and ability. Therefore, Janine should get a full refund. You see it as the obligation of the adult to make sure that the person they are dealing with is within the legal age. Insane persons are also given the same protection as minors. Persons entered a contract so intoxicated so as not to be able to understand the nature of the transaction can cancel or ratify the contract. Intention to create legal relation. Contracts are only enforceable when they have a legal purpose. Forming contracts that violate legal statutes is illegal and invalid. For instance, a contract is invalid if Company A promises to pay Company B if they, Company B, misrepresent information on certain products that Company A sells. You now see why arrangements of a social nature are not considered legally binding. Commercial arrangements are generally presumed to be intended to be legally binding. A closer look at the details of any commercial arrangement will help you determine the validity of these arrangements and thus determine if they form a valid contract.